Hello. Yeah. Good morning. And thank you for having me. I'm so glad to be here this morning. And I'm sure that for the past previous weeks, we've had something to take home, right? Yeah, that's good to know. And we're continuing today. And of course, I'll be taking, we have two baristas in the house. The other barista will take us on other legal frameworks. But as I am concerned, I'm going to be taking the land titles in Nigeria. I know a lot of us have questions as far as land titles are concerned. We buy properties, we sell properties, and we raise questions as to who, as to the titles of the properties that we're actually buying into, right? And that is why I'm here to talk to you as realtors, for you to understand what land titles are, what you should look for in your land titles, what makes it a valid land title, right? And that's why I'm here this morning. So, okay, thank you. Next slide, please. All right. So, introduction. A land title is a legal document that confirms ownership, rights, and interest in a property. It confers ownership. It transfers ownership. So we hear some things, and at times we hear receipts. Does receipt transfer title? No, right? So it confers ownership. That is what title does. And we talk about root titles because there are some titles that are actually not titles, but we assume they are titles. So we talk about root titles, and that is what makes it valid. Proper documentation prevents land disputes and fraud. Of course, for a title to be called a title, then it must be registered. So is your title registered? What are those things to look out for? What makes it a registered title that you can use to that will make you to prevent dispute and of course fraud when dealing in land transactions? Required for land transactions, development, and securing loans. If your title is not registered, you cannot go to the bank and borrow money. They won't answer you, right? So it has to be a registered title for you to be able to take loan with it from banks and all of that. Next slide, please. There's what we call the Land Use Act of 1978. And the Land Use Act of 1978 vested land titles to the state government. So where we are seated right now at a point was actually owned by the state government. So every state you go to, the state actually owns the property and not an individual. That is what the law actually states. Now, okay. The Land Use Act vests all land in the state government which holds it in trust for the people. It requires obtaining a certificate of occupancy for legal land use and provides a legal framework for land tenure and administration. That is what basically what the 1978 Land Use Act is all about. Next slide, please. So what are the recognized land titles in Nigeria? What are the recognized land titles in Nigeria? We have the certificate of occupancy. We have the deed of assignment. We have the deed of conveyance. We have accession stroke gazette. I know many of you will start asking, why did she put a stroke gazette? I will explain all that to us. Deed of gifts. Like I said root titles. Many of us, especially developers, you hear something like survey, you hear something like receipts, and they tell you those are the titles. Those are not titles. Those are not root titles because they actually do not transfer ownership to the buyer, to the new owner. And that is why my list is very short. Very, very short. I have some other lists I would have loved to mention, but I would not want to confuse us, further. And that's why I just limited it to this, right? But if you're talking about title, we're talking about this that I've listed here. Next slide, please. So I'm going to take them one after the other. We have the certificate of occupancy. Like I said earlier, Land in Nigeria is vested in the state government. That means you and I do not own a land until we go back to the government and apply for a C of O for a land that has been released to us. Do we understand that? Now, a C of O is a document that transfers ownership of a state-owned released land. Until the land is released, you cannot obtain a C of O on the property. Now, we have a lease, we have a freehold land. I will explain this in history. When in 1978, the lands were vested in the state government. And of course, you know there are communities. Like, okay, mention one community around here. Ogombo, right? All right. Existing communities where we have rulers on in those communities rather. Now, of course, the fact that land was actually vested in state government does not mean that they would, chase the original customary owners of those lands away from their lands, is it? So they left those communities for these communities. That, okay, we have the lands, right? But because you've been here customarily, you've been living on this property customarily, these are the lands of your forefathers, right? We're going to leave you on those properties. And it is called leasehold. That is, it was not acquired in the first place. Do we understand that? It was not acquired in the first place. That is what we call freehold lands. So those communities enjoy absolutely the lands of their forefathers. They are the first settlers, and they, enjoy that land absolutely to themselves. Now, when somebody like me or you go to them and tell, oh, we want to be part of your community, I want to buy a property on your community, the next questions that is being raised is, how do I make this land primarily mine? I don't want it to be that of the community anymore. After all, I've bought it, isn't it? It belongs to me. So when you buy such properties, the next thing you want to get on that property is a C of O. You only get a certificate of occupancy on leasehold lands. Do we understand that? I mean, on leasehold lands, it is free. No existing title as far as government is concerned. Because if you go to survey in Alausa, what it will show you is, okay, this land is for this community. The community owns it as far as, so government does not have interest in such lands. They don't have any, it's not acquired by government. But you want to get it for yourself legally. To do that, all you have to do is apply for a certificate of occupancy. And that makes it yours because the ownership is being transferred to you absolutely, not absolutely, sorry, 99 years. 99 years, for a period of 99 years. So it expires. It does expire. So somebody like you and I, when we are like 99-year-old and we still have our property, but that's not possible because if I were to be 99-year-old, that means I bought that property when I was actually 1-year-old, right? Or probably 0-year-old or something. So somebody like our children would now come back and say, oh, this C of O has expired. How do we go about it? Somebody contacted me yesterday and was talking about we have an assignment on this property and is going to expire and all of that. I'm like, so you apply. Unfortunately, the father is late. And the property is actually in favor of the father. So what happens, right? You have to apply, but there are rules. That's why I said I don't want to confuse us because there are other things that are being considered in a child having to apply or a family member having to apply for a dead relative. So I won't go into that, so I won't confuse you further. So I mentioned this certificate of occupancy, which is issued by the state government. It grants a leasehold for 99 years, and it is required for landowners, for all landowners, to establish legal ownership, often needed for obtaining building permits and loans. But of course, if you want to obtain your building permit, they will ask you, where are your title documents? When they're asking for title documents, they mean the registered ones, not the one your lawyer at the back of your house prepared. You signed, the seller signed, but of course, that's not going to allow us, because I know that's very common in this axis, right? I'm talking about a registered title. Next slide, please. So I want to believe you understand what a COO is all about. All right, thank you. So a deed of assignment. A deed of assignment. A lot of people use this freely, but we really need to understand what it really means to have a deed of assignment. Now, having acquired my property, for example, and I've obtained my COO on that property, and Barrister Blessing comes to me and says, I love this, your land, I want to buy it. And I'm like, why not, if not? I want to sell too. I need your millions of naira. And then there's a transaction. What she would get from me, I have the COO on that property already. What she would get from me is actually a deed of assignment. What a deed of assignment does is transfers the remaining years. It only transfers the remaining years of what I have already. Probably I've bought the property and I've spent about 20 years on the property and I have like 80 years left of it, and now she wants to buy. I'll be transferring 80 years of that property to her. 80 years of the ownership. So she can only own it for 80 years. That is why it's called a deed of assignment. I'm assigning parts of the years, the remaining of the years to her. So when we use it too freely that we don't, even lawyers at times get confused as to, because there are some documents I see from other lawyers and I begin to wonder if we went to the same school. I'm sorry to say that though. If we went to the same school, because it gets people, if the lawyer is confused, I can imagine what the client would feel or what other people out there. I have people come to my office, lawyer, please, I want a deed of assignment. And I ask you, what is a title? And you begin to look, no, family land, no, it's a family land. And I'm like, so why are you asking me for a deed of assignment? I know they may not know, but it's surprising that lawyers prepare a deed of assignment for properties that do not have existing titles, that do not have an existing SCOO. That's why I said even lawyers confuse their clients. So the first questions I ask you when you tell me I want a deed of assignment, I will assume that you know what you're talking about. If you tell me you want a deed of assignment, it's better you just come to me and say, lawyer, I bought a property, I need to prepare a document. Then I'll start asking you the necessary questions. So I will know what I'm going to prepare for you, if it's a deed of assignment or not. A deed of assignment is a legal document transferring ownership from a party to another, from one person to another. Must be registered at the land registry, used when purchasing property with an existing COO. Provides legal proof of transaction history. When I see a deed of assignment, I know what I want to look at in the deed of assignment. The first thing I want to look at is the recitals. The recitals gives you the history of the land. I bought from the Omoniles, isn't it? And I obtained a COO. And Barrister Blessing has come to me. She has bought from me, right? And probably prepared a deed of assignment. And this, my beautiful sister here, comes to her and said, I want to buy your property. Now, that recital should have a list of the history of how far that land has gone. Then I will tell you that the family of Abiola, whatever, are the customary owners, the first settlers, right? And Barrister Opeyemi at so dates with an executed COO with so dates, right? Bought it from us, bought it from the Abiolas, right? And Barrister Blessing, by virtue of a deed of assignment, executed on so dates, I'll write the history. So that when you want to buy, or somebody from somewhere sees such documents, oh, this is the history of the land, this is how far it has gone, and these are the titles that has been on it. So when such documents even gets to Alausa, the Alausa, that's the first thing they want to look at. They want to know, okay, this document, this registered number, this. And then they know how to make their own research on such property. So, provides legal proof of transaction history. Next slide, please. Okay, you can change that. But then, we hear consent, right? Governor's consent. What is a governor's consent? I will tell you that a deed of assignment is the same, in quotes though, as a consent, because at the end of every deed of assignment, it's just a consent of the governor saying, I acknowledge this transaction and I'm signing it off, right? I acknowledge the fact that Barrister Opeyemi actually owns this property. And I acknowledge the fact that Barrister Blessing has bought from her and she has transferred the remaining years to Barrister Blessing. So it is okay for Barrister Blessing to continue to own 80 years of the remaining years. That is what governor's consent is. That's why I said stroke consent. I know some of you will ask me questions as to why I didn't talk about consent. When I talk about deed of assignment, I talk about consent. The reason why we are confused is the fact that we don't perfect our titles. We prepare these documents and keep it in our house, and you tell yourself you have a deed of assignment. Yes, you have a deed of assignment without consent, and it makes it not valid. If, for example, I have a property, like I have a property that I bought from the Omoniles, and I did not perfect my title. For example, I have bought from Omonile, but I refused to actually file for my own C of O. And then Barrister Mercy wants to come buy from me. I want to sell. Yeah, I will sell to her. But if she's going to perfect her title, she's not going to come through me anymore. Do you understand? Because my name is not actually registered in Alausa as the owner of that property. Do you understand? So she needs to go through the family directly. So to be as if she's buying directly from the family. So that by the time she gets to Alausa will know that, okay, these are the first settlers, the Abiolas, and Barrister Blessing has bought from the Abiolas, right? So it is a back-end transaction that she actually bought from me. And that is why perfecting your titles are important. Deed of conveyance. I know that I get a lot of questions. What's the lawyer now? Okay, one is deed of conveyance. Which one is now deed of conveyance? Like it says here, used for land transaction before the Land Use Act. And then it used to transfer absolute title, absolutely, to the owners back then. It's just like deed of assignment, or C of O as we may call it. But it used to be used before 1978, before the Land Use Act, deed of conveyance. But funny enough, you go to places like FCT, and you see here them using the word deed of conveyance. But of course, you should always hear, because somebody like my grandfather who bought before 1978, if he brings out his documents, you will see a deed of conveyance. So you don't get confused as to why did they use the word deed of conveyance. So it's still relatable till now, because we have people who still have such documents with them, carrying such titles. All right. So next slide, please. Excision. I actually did excision through Gazette, but I want to explain it one after the other. And it's very, very straightforward, very, very straightforward. From the history that I gave you, lands were vested in government by virtue of 1978 Land Use Act. Now, after they were vested in state government, the government now comes back and says, oh, we don't need this land. We want to give it back to the community that owns them originally, right? And not because most times, not because government actually comes to the family, or they have nothing to lose. I mean, they won't want to release it after all. If I were you, would I? But of course, the community applies for it. This is still part of our land. I mean, this is still part of our land. Yes, we are settled here, but this were our farms, this were our this and that, and we still need our land. And especially the fact that places like the Lekki axis is growing rapidly, developing rapidly, and all of that. So, of course, they want their land so that they can sell and make cool cash. So they apply for excision. And like the word says, excision, excise, to remove. So remove up from the acquired property, the government acquired property. So there is about, releasing some parts or whole of the family land that has been originally acquired by the states. So when they release it back to the people, it becomes an excised land with an excision number. So when you want to buy a property or you want to sell a property and you hear something like excision in view, my dear sirs and mars, I'd advise that you stay clear from it. Why? What if they don't release it eventually? What happens? It still remains the government property. In view is not a certainty that it will be released, isn't it? Government process of releasing land back to indigenous communities must be documented to avoid acquisition issues. A stepping stone to obtaining a C of O. Now, must be documented to avoid acquisition issues. Of course, like I said, you applied for acquisition. You have not gotten it. Has it been documented? No. So, of course, to avoid stories that such, you need to have it registered. Have your acquisition number, right? When you have your acquisition, when it's being released, you're given an acquisition number, and you, of course, there's a map as to where and where it's being released. Then a stepping stone to obtaining a C of O, it helps to differentiate between government-acquired land and free land. It helps to differentiate. There was a time a client from, I think, UK or somewhere, called and said she wants to buy a property from a developer, a real estate company, so to say. And somehow she has actually bought properties from them before, so she has this confidence in buying from them again. But somehow I really don't know what happened to her that moment. And she called me and said, "Please, I got your number from somewhere. I need to do search on this property." She told me I've bought from them before, but I just feel like I should just do a search on this property. And then I did a search. I asked the developers, I had to call developers, okay, what do you have? We have accession. They gave me the accession number. I said, no, it's not sufficient for me. I need the map, right? I need the survey. They sent me the survey. So I went ahead and I did my research, my search on the property. Actually, let me do this illustration. This land, this old land, an accession was given to from this side to this side. Now, the real estate company actually owns this side of the property. Does the accession cover this side of the property? So he was actually relying on the accession of this property, isn't it? But he gave me the accession number. He was distributing the accession number. So when we go there, you get to allow, sir, they tell you, oh, yes, the accession actually exists, doesn't it? Just tell you the fraud that may go on, even within the real estate companies. Do you understand? Now, when I insisted that I do not want the number, I'm not okay with just having the number, because I know if I go there, it would actually exist. After all, for you to confidently give me such number, you know that it does exist. But does it cover this part that you're actually talking about? That's what I needed to know. And so they sent me the survey, and it came back like, yes, there's an accession, but it does cover this side of the property. And this side, which the estate owns, is not within the excised area. So that's why you need to be extra careful when buying property. So it's not sufficient to just rely on accession numbers, C of O numbers, and all that. So you take your survey and do the required search. Okay? Now, this is a gazette. After an accession must have been given to you, the next thing is for it to be published in a gazette. So it is the same thing if you have an accession number. But it's possible for you to have an accession number which is yet to be gazetted, which is yet to be published. So until it is published, you cannot talk about having a gazette. Right? And it is a root title because it is actually recognized by what? The government. The government actually gave the accession number and actually published it out to be a gazette. So that is what makes it a root title. So it confirms the land has been released from government acquisition, used to process a C of O, serves as an official publication of land acquisition. So that's basically what it does. It only serves as an official publication of land acquisitions. Do we understand to that extent? Thank you. So that's what a gazette does. It gives official government record of an excised land. Next slide, please. Okay. What are the myths about land titles? Myth about land titles. We have questions. Like I say, people ask, we believe some certain things we should not believe about land titles, right? And so that's why I pulled this up. Possession of a survey plan means ownership, yes or yes? Possession of a survey plan means ownership, yes or yes? Thank you, no. I got you confused saying yes or yes, right? No, it does not mean ownership. It's not. The only thing a survey does is to map out your land, tell you where your land, this is point A to point B. That is your land. No, it doesn't give you ownership. It's just for you to understand so that you and I will not start fighting over land. If you know where your own point A is, point A to B, I know that my own starts from C to D. And so we won't start fighting ourselves over the, ownership of lands. It only gives you clear map as to what belongs to you and what belongs to your neighbor. That is what it does. And of course, in Alausa, it helps you to understand where your land is. In this house, Nigeria is very big. You just know this is where my land is. And it's, of course, of your general's office, you wonder why it's on its own. I mean, they do a lot in that office. They need to know which land is, which land has been acquired, which land has been, bought, which land is for the community. Which land has been acquired for certain purposes, hospitals, markets, and all of that. That is what they do there. So the next one is a deed of assignment is enough proof of ownership. A deed of assignment is enough proof of ownership. Yes or yes? Yes or yes? Yes or yes? A deed of assignment with consent. With consent. That's why I said it needs to be consented. Most of you prepare your deed of assignment and keep it in your rooms. You don't do the necessary, which is, filing for consent at land registry. Until you do that, you are just carrying paper. If I buy that land, even if you are living on that land, if I buy it and I go to Alausa and perfect my title, God will chase you from that land. Do we understand? So it is important that you file for consent. It is important that is what government understand. They don't understand that you bought from someone. They don't understand that. It is between, that one is an argument that you go to court for. I bought from him. If you bought from him, what are your titles? He signed this. You too, why did you sign this for him and sign for B? But unfortunately, B has consent. Oga, you don't have consent though. As far as we are concerned, it is B that has, and you are the Mr. He who has been living on that land. Do we get? So, consent is important. A family receipt is a valid land title. A family receipt is a valid land title. Thank you. It is a no. It is not a land title. It's just a transaction. Just like you go to supermarket and you buy things, they give you receipt. Right? That's just about it. To give you receipt, okay, you bought it from me. I understand that you bought it from me, and I acknowledge the fact that you bought it from me. That's all. As far as government is concerned, they don't know you. They don't. Land with excision is automatically safe. It's automatically safe. No. Yes, no, until it is published. I keep saying it because what if they withdraw excision? The government we have these days, they wake up one day and that land I signed off yesterday, I don't think I want to sign it off again. After all, it's yet to be published, isn't it? Until it is published. So it's always important. I'm more confident in lands that are gazetted. If you tell me it's gazetted, okay, they will start talking. But if you tell me it's excised, okay, it's excised. Yes, they've released it, but when are they going to publish it? What are the, I need to understand those things. I'll be certain that it's actually, gone absolutely to the communities. All right. A certificate of occupancy lasts forever. Yes or yes? Thank you. It lasts for 99 years and, of course, must be renewed on expiration. Land without title documents can never be reclaimed. Yes or yes? Yes or yes? Land without title documents. Without land documents can be reclaimed. Yes or yes? Yes. It doesn't have title documents now. They wake up one day and tell you, who gave it to you? That's the question. Did I give you the land? No. So if I did not give it to you, how are you now claiming the land? That's what they will ask. Of course, they will reclaim it back. Because as far as they are concerned, in their system, in Surveyor General's office, the land still belongs to them. You have not done the necessaries. So many of us in Lekki houses especially live on these properties. It's more like a time bomb waiting to what? Explode. That is what we actually live on. Because they wake up one day, they tell you it is not yours, and they are correct because you actually did a transaction, you signed documents with whoever you bought from, and kept it in your room. You did not do the necessary. You did not do the necessary. So when we are buying properties, when we are selling properties, it is important for us to understand these things. Actually make sure they did of gift, right? Deed of gift, just like the word says, gift. If it's assignment, she paid me. She paid me, and so I will sign off a deed of assignment. But if I'm giving it to her as a friend, of course, it becomes what? A deed of gift. That is the difference. Now, I mentioned a friend about his father dying and all of that. So, in such issues, we have where you have to obtain probate. Probate, where the man has died, testate with a will. And where he has died intestate, we mentioned the word, the phrase letter of administration. So when it is where you obtain this, it is not a root title, but it gives you the legal right to transfer the ownership. So that's why I don't want to confuse us, because it is not a root title. It only gives you a legal right to transfer ownership on behalf of the dead. It's either you get a probate or a letter of administration, as the case may be, to do that. So thank you very much. I hope we do understand how far we've come.